My name is Alan Rawl. I'm a partner at Sidley Austin in Washington, D.C. and New York City offices. And I'm proud to have been a founding member of Checks and Balances. I'll tell you a little bit more about Checks and Balances for those who may be new to the group. But I'm very much looking forward, as I know the audience is, to speaking in a moment with one of the most distinguished conservative jurists and lawyers, indeed, most distinguished jurists or lawyers of any ideological stripe in the country, the Honorable J. Michael Luttig. First, let me extend a welcome to the audience and a little bit of housekeeping. Today, we've opened up this session to Checks and Balances members, but also we hope that members of law school and local Federalist Society chapters and other law students and legal practitioners have been able to join as well. Checks and Balances is a group comprised of conservative and libertarian lawyers, like-minded constitutionalists, and others interested in defending the rule of law. After a conversation between Judge Luttig and myself, we'll open it up to the audience for questions. Questions can be extended and communicated to us through the Q&A feature in the Zoom box down at the bottom in the middle. So please feel free to send us your questions and we'll try to answer them as we can. I'm going to just provide a little bit of background on Checks and Balances for those who are new to our calls and our conferences and don't know quite as much about C&B as those of us who founded the organization back in November 2018 as organized really by George Conway, who's been the leader of the group since our founding. Our mission statement, which is available in full for anybody who is interested on Checks and Balances website, which is checks-and-balances.org. But just to give you a flavor of what our founding mission statement is that we are a group of attorneys who would traditionally be considered conservative or libertarian, who believe in the rule of law, the power of truth, the independence of the criminal justice system, the imperative of individual rights, and the necessity of civil discourse. We believe these principles apply regardless of the party or persons in power. And we seek to provide a voice and a network for like-minded attorneys to discuss these ideas, and we hope they will join with us to stand up for these principles. So that's a excerpt of the flavor of our mission statement, and feel free, of course, to visit checksandbalances.org to see the full statement and who's involved in the organization. So without further ado, as all of you who are joining this session are certainly very well aware, Judge Luttig served with great distinction for 15 years as an appellate judge on the Fourth Circuit Court of Appeals. And first, Judge Luttig, would you mind, is it okay if I call you Mike for our conversation? After all, when I was a government GC and you were Assistant Attorney General for the Office of Legal Counsel, I really think I was one of your clients. So if Mike is okay, can I go with that for today?
You and everyone else can call me Mike, or for that matter, anything else you want to call me, Alan.
All right. Distinguished jurist and lawyer and Mike. So thanks for that. And thanks for joining us today, especially after the fabulous op-ed that you published in the New York Times. I'm going to call it the Valentine's Day op-ed. And we'll have occasion to talk about that. Since we may very well, and we hope to have a number of young lawyers and law students who are joining the virtual, who are in our virtual audience, I think it would be particularly interesting to hear a little bit about your personal career path toward becoming the icon conservative lawyer and government official that you are. What got you to the Fourth Circuit? How did you get involved in government and politics? And what started you off after Washington and Lee and University of Virginia? Where did you head from there?
Yeah, thank you, Alan. First, let me just say it's really my honor to be here today with this group. by way of confession, I'm more than a little bit intimidated. I actually believe that I should be in the audience listening to all of you rather than vice versa. My good friend, Rich Bernstein, timed an email to me perfectly about 1 minute before he went on. And he said, watch what you say, I'm going to be on. And I pled with Rich not to correct me too often, that it would be embarrassing. But in all honesty, in looking over your roles, look, many of you are dear and longtime friends, and I have just enormous respect for all of you, and I'm honored to be here. But you're going to talk to me as much as I'm going to talk to you, hopefully. But Alan insists upon, a digression at the beginning about my biography, which all of you know. We're going to keep that very short. But it was really in law school that I guess I had the privilege to intern at both the White House and the Supreme Court. At the White House under a president that few people today even remember was a president, and that's Gerald Ford. Not to age me and Alan, but right out of that internship, I had what truly was for me a great privilege of going directly to the Supreme Court of the United States and working first as an intern and then as an assistant to then Chief Justice Warren Burger. When I went to when I was trying to decide whether to leave the White House and go to the Supreme Court, my dad, who has since passed away, said, "Son, everything you believe in life is at the other end of Pennsylvania Avenue." He said, and everything that you despise in life is where you are right now. So that would be my advice. Go to the other end of Pennsylvania Avenue. Thereafter, I went to law school, to undergrad at Washington and Lee, as Alan said. And, during those years, really decided not just that I wanted to be a lawyer, but I actually wanted to be a federal judge. And that's the only thing that I've ever wanted to do in my whole life. And of course, I had the great honor to have been able to do that, at upon the appointment of President George H.W. Bush, many years ago. But after law school, I got a call from a man by the name of Fred Fielding, whom I did not know, literally the day of the inauguration of President Ronald Reagan. Fred asked me what I was doing, and I was so caught off guard in what we lawyers call an excited utterance. I said, well, Mr. Fielding, at this very moment, I'm standing at attention as President Ronald Reagan is sworn in to be our next president. And, he chuckled and said, look, I'd like for you to come up and talk to me about coming to the White House next week. And so I did. Fred hired me, and I actually began working at the White House for Fred Fielding and Ronald Reagan before I finished law school. Before I completed law school. And during that interim between the time I started and finished law school, of course, President Reagan was shot by John Hinckley, and so at that very time, I started getting into constitutional law, if you will, by virtue of the issues surrounding the 25th Amendment at that point. So after that, I went back to the Supreme Court to the DC Circuit to clerk with then Judge Antonin Scalia, and then on back to clerk with my former boss, Chief Justice Warren Burger. After that, I did a short stint, 4 or 5 years at Davis Polk and Wardwell, and then went into the Bush Department of Justice under Dick Thornburgh with Bill Barr at the Office of Legal Counsel. A year later, Bill was elevated to Deputy Attorney General, and I became Assistant Attorney General and counselor to the Attorney General. And then a year or so later, Alan, Bush put me on the Fourth Circuit. And so in realization of what had been my lifetime dream.
Well, that's just obviously a fabulous personal history, and your conservative bona fides are well established and highly secure. I know that
those have never been questioned.
never been questioned, as is the case for many of the members of Checks and Balances who have taken issue with some of the conservative party's stands or lack of stands, but our conservatism really holds firm and shouldn't be questioned, even though we've taken the opportunity as individuals and otherwise to speak out on certain issues. You've also had a stint as general counsel of one of America's greatest companies and largest companies, and that also would undoubtedly gave you a perspective on issues of the day that you wouldn't necessarily see in the Office of Legal Counsel and the White House counsel's office and on the bench. Did you enjoy that stint as well?
I did, Alan. In my resignation letter to the then president, I said something like, Boeing is the only company that for which I would leave the federal bench, because it was such an iconic American company, frankly. What was my time there ever like my time on the federal bench? No, they're just polar opposites of positions. But I loved every minute of that time there. Well, I had many constitutional issues come up. I remember one day someone called and said, Judge, we've been sued by the ACLU. And I said, what? The ACLU? And I said, what on earth would they be suing us for? And they said, well, they allege that we flew terrorists out of the country to foreign countries to be, persecuted. Now, I guess I can say this to this group, but I probably shouldn't. I said, well, what's wrong with that? But that began a saga in the federal courts that led right up to the Supreme Court, and with a stop at the Department of Justice under the new president Obama, and Obama said, well, we're not going to assert state secrets privilege over this, because as you remember, that had been a big part of the campaign. That Bush had and Obama wouldn't, assert, state secrets to protect such information. So I sent a message to the Attorney General and said, well, look, the state secrets privilege is yours to assert, not Boeing's. If you don't want to assert it, I'll just dump all the documents out on the streets of Washington tomorrow morning. Well, we got a call from the Department of Justice that said that would not be necessary. They would indeed assert the state secrets privilege. That case went on to the Supreme Court, and the Supreme Court affirmed the government's assertion. So I had lots of fun issues that I never expected at Boeing, Alan.
What an amazing career. One last point on the career before getting to the matter at hand on the Electoral Count Act and the subject of your op-ed and great work advising various political officials. Did I read in your background correctly that you had a role in taking certain nominees through the confirmation process and helping advise judicial nominees?
You probably did, Alan, and that's been one of the greatest honors of my life. I've been involved in almost all of the Republican nominees to the Supreme Court, beginning again to age myself with John Paul Stevens when Gerald Ford appointed him, continuing to where I was intimately involved with the appointment of Sandra Day O'Connor, and then I actually did shepherd through H.W. Bush's appointments of both David Souter and Clarence Thomas.
Interesting. You must have really done all of this in high school. So very impressive that at such a young age you had such a role and such influence. You mentioned that you worked with Bill Barr in the Office of Legal Counsel, then succeeded him as Assistant AG. I think it's fair to say Bill Barr's played a role in a lot of the last administration's, last president's legal decisions, obviously, as Attorney General. Also, he declined to support the allegations of widespread fraud. Are you still in touch with them? And have you talked with them about your views of the Electoral Count Act and the last election, if you're comfortable talking about it? A lot of us here in this group know Bill Barr, but if that's something you're willing to comment on, he obviously played a critical role in the last administration.
I'd be glad to, Alan. Bill and I are longtime friends, beginning even before our time at the Department of Justice together. And then, of course, I'll put it this way: it was reported that Bill and I were the two people under consideration to be Trump's Attorney General. We talked extensively during the month or two leading up to that. First about whether one of us should do it, and thereafter as to which one of us should do it. In my view, Bill drew the short straw, and it couldn't have happened to a nicer fellow, as I've told him. Look, I'm very much aware of all the discussion and debate about Bill and his role in the department. Even especially the criticisms of a good number of your group, that were leveled at Bill during the time. I think as to all of that, I will only say this. Bill, had to face into some of the biggest, most controversial, legal issues possible. For an attorney general, being the attorney general for Donald Trump. I'm sure he did the best that he possibly could have, but I wish for his sake he had never taken the job, Alan.
Thanks for sharing those thoughts, and I think a lot of us agree with you on that point. As his as his longtime friends and admirers, and then also critics. So turning to your Valentine's Day op-ed, by the way, I'm going to come back and ask you about other conversations, for example, that you may have had with Vice President Pence, but we'll come back to that in a little bit, I hope. But you did, as you noted, obviously, Bill Barr served as Attorney General for former President Trump, and just yesterday you began this brilliant and really very substantial in terms of its reasoning and its suggestions, your op-ed, Valentine's Day op-ed in the New York Times, and you began it with a reference to the clear and present danger to our democracy as a result of former President Trump's intentions. You've also described the possibility of exploitation under the Electoral Count Act as an existential threat to the Republican Party, and then come back to democracy, saying it's hardly an overstatement to say that the future of our democracy depends on reform of the Electoral Count Act. So obviously your audience today is very interested on your thoughts on how that could happen. I wonder whether you want to start at all with a little bit of history on how we got the Electoral Count Act, which itself has a checkered past as well as, of course, a checkered present. And then tell us about your thoughts on this clear and present danger and existential threat posed if we leave it in place.
Well, wow, Alan. By my count, there were probably about 10 embedded questions in that asserted single question. But look, this is, let me try to unpack it for this group. I'm sensitive about it because, as I told you, in the past 24 hours, I've been asked to come on about every interview show in America to discuss the more sensitive parts of the essay, which I can assure you were not my suggestions for reform of the ECA. All right, but I love this group, and so let's talk it over, and I'll just tell you everything. All right. First off, I don't think that I said that the ECA was an existential threat. I think what I said was that the division within the Republican Party over Trump represented an existential threat to the Republican Party. Okay, think of the essay as I know you did as two parts. The first half being the political introduction to the second half, which was the legal half, proposing changes to the ECA. Look, I did fall off the turnip wagon, but I didn't fall off yesterday. I knew good and well what I was doing, and so did the New York Times. And I decided to do it. All right, and here's why and how that came about. Just like the rest of you, I was sitting there last weekend, which Greg Sargent of the Washington Post characterized as a seminal moment in our history. He, to his discredit, he actually suggested, I think, that my op-ed was a seminal moment. But what he was really referring to was this aggregation of events that I think serendipitously converged last weekend. although I'm not sure it was serendipity, because all of it was planned to a large degree, I think. Namely, the Republican Party came out and censored, Liz Cheney and the other fellow's name that begins with a K, and I apologize, I can't remember it.
Kinzinger.
Yes, Kinzinger, who are serving on the select committee investigating January 6th. Calling, upbraiding them and censoring them for their participation on that committee, and then calling January 6th, civil discourse, and of course that was unbelievable. Well, then the next thing that happened is Leader McConnell stepped forth and upbraided the Republican Party, both for the censure and also for calling the January 6th the civil discourse. And then at about the same time, the former vice president decided to step forth and address January 6th at a Federal Society meeting in Florida, at which he forcefully repudiated the former president's criticism of him that he had the power under the Constitution and the law, in Trump's words, to overturn the 2020 election. Of course, no sooner than the vice president had finished his speech, then predictably, the former president, joined issue with him, saying in clarion language that he's capable of, no, I'm not the one that was wrong. The vice president is the one who's wrong. He had the authority and the power to overturn the election, and he was too weak to do it. Well, so I'm sitting there watching all of this with all of you, just like all of you, and sitting right here where I am in Charleston right now by myself, and I thought, this is the moment. The moment being this: for the past 6 years, I have watched and listened in disgust that not one single leader of ours with the moral authority, the courage, and the will to stand up and say, no, this is not who we are. This is not what America is, and it's not what we want to be, has done so. I have, for 6 years, considered this the paradigmatic failure of leadership. And it's not my job, to do this. I'm the last person whose job it is to do this. But Alan, I've been frustrated out of my mind that, like I said, not one single person has had the courage to stand up and say no. So, I had been thinking about an op-ed on the ECA and had been advising some of the senators. And then I just thought at that moment to myself, okay, I got it. This is what needs to be done. And I wrote the op-ed.
Yeah, well, thanks for the context that led up to it, and your explanation, which is apparent in really your lapidary prose in in the New York Times. You definitely have a future and certainly a present as a columnist and op-ed writer. I've seen many of your articles, and looking back on it for today's talk, I see that you really are writing on a pretty good clip and regular schedule. So keep it up. This piece is really fantastic. You talk about, you've discussed to this point, as you did at the beginning of your piece in the Times, the political dimensions. Turning to the Electoral Count Act, which is as I think you put it, vague and ambiguous and convoluted. I love that. It is that indeed. Why do you see, again, to quote you, I think I've got this one right, hardly an overstatement that the future of our democracy depends on reform of the Electoral Count Act. Why do you see that danger, and what can be done about it? What should be done about it?
Well, there are obviously a number of foundational pillars of our democracy, all of which collectively make our democracy firm and sturdy. But one of those pillars is the Electoral Count Act, which we've given very little thought of in the 135 years since its passage, although we should have been thinking about this since the beginning of the Republic, because it was in the elections of 1800 and 1804 where the fundamental problems began to emerge. In those years, for instance, among others, it was that the 12th Amendment, did not anticipate and contemplate, for instance, separate votes for the presidency and the vice presidency. And then it began very early to emerge that neither had the Constitution contemplated and anticipated multiple slates of electors coming from a single state. And then, of course, it was not until 100 years later, in 1887, that Congress finally addressed these emerging problems. And then, of course, as Congress can do, inadequately address them, even when it did address them, leaving the call it loopholes, if you will, that Trump and his congressional allies and his his allies in the states exploited in the 2020 election. Now, I will say this, it is not a model of clarity. It is convoluted as heck, but it's actually quite clear in its most pernicious provisions. Those provisions giving the Congress of the United States to decide the presidency in a host of circumstances which themselves are ambiguous. So that's kind of a lawyerly distinction, but a fundamental lawyerly distinction. So as I tried to clearly state in the op-ed, the problem is that the act gives Congress the unconstitutional power to decide the presidency in a host of circumstances, and then makes those circumstances expansive, if not complete, because of the ambiguity in the terms in which the Congress can contest and eventually overturn an election. So so that was what I was going to address in the op-ed. Now, as all of our listeners can appreciate, in an op-ed, it's hardly better than a tweet. You get 180 characters in a tweet, and you typically only get 700 words in an op-ed. That's the most frustrating thing for me in the world. Now I've written, I think, a dozen or more of these things in the past 2 years, and so I've really loved it and enjoyed it. But it's not really something that lawyers should ever try to do. But so by the time I finished the political half, I didn't have any words left for the Electoral Count Act, which I think the New York Times thought that was just fine. I'm not under any illusion that anyone thinks that my thoughts about the ECA reform matter, but I only had a little bit of space left to just tick off the 4 or 5 things that I thought were necessary.
Do you view the Electoral Count Act as in the genre of no good deed going unpunished? The act, as you know, and as most of our listeners may know, was kind of, as I understand it, I'm not a historian, but I understand that it was adopted by Congress in the aftermath of the Hayes-Tilden disputed election and disputed, ballots and so on, and which electors were authorized, and that resulted in what has been described as a ugly compromise in Congress, and that the act was actually intended to try to improve things so that we wouldn't have a disputed election that would go to a commission and maybe with corrupt deals of all kinds behind it in order to give the election to Hayes and not Tilden. Were they trying to do the right thing, you think, back in 1887 and just got it wrong, or did they just draft it poorly such that words like regularly given and legitimate and so on could be exploited by ill-intentioned politicians?
Yeah, no, Alan, I don't think of this as an example of a good deed punished. I think that there was not just a want, but a need to address the problems with the elections, a fundamental need to address them. Nor do I think that the 49th Congress failed in its responsibilities. I think it's more nuanced, much more nuanced than that. If there was anything wrong about their effort, it was only, and I phrase it that way, only in their eventual decision to give themselves the power to resolve this vast array of disputes with state electors. But I don't even criticize them, much less hold that against them. I think that in fact, their articulated intent was to limit Congress's power to decide the presidency. And I think that in employing the specific language that they did as to lawfully certified and regularly given, I think that was not just a good faith, but a pretty darn good faith effort at limiting Congress's role. And it was the events thereafter, and really just specifically in the election of 2020, that have cast a negative light on what was a pretty precise piece of legislation for the Congress of the United States, to be honest.
Yeah, I mean, the insurrection of 2021 rather, over the election of 2020 was sort of a black swan event. Who would have thought? Who would have thought that we really could have such an effort to overturn the election, both through a riot and through efforts to persuade and pressure the vice president to do more than count the ballots. I wanted to, you mentioned Rich Bernstein at the beginning, and that he warned you he'd be on, so you better teach it straight. Rich Bernstein and I wrote a piece in the Wall Street Journal on the vice president's role, that he was limited to counting the ballots. In your op-ed piece, I found it interesting that you mentioned that the vice president's role is important. I'm quoting the op-ed, important, and quoting again, largely ministerial. So I was just curious as to whether you want to take issue with your friend Rich Bernstein and my co-author about the vice president's role, and frankly, maybe you can tell us what you told him about it. Is he limited to just counting, or what is it about his role that you view as more than ministerial?
Yeah, I'm not going to take the bait there, Alan. I'm smarter than that. I reread and reread several times back at the time yours and Rich's op-ed, and as usual with everything the two of you do, and separately and collectively, it was right. It was correct without any question. Now.
Hey, you had me at right without question. We can move on. No, finish.
So the fast forward then, to 2020, and my advice to then Vice President Pence, that advice was unequivocal. As surprising as it was that it came in a tweet that was considerably longer than 180 characters. The only way that was possible was because I brought in my tech-savvy son in the wee hours to help me do that. Then fast forward a year later to the op-ed, not to diagram the op-ed more than I already have, but once I turned to the ECA, I had very little space and time, and the most important point that I wanted to make for the country and for the Congress was not that the vice president's role is critical and what led to January 6th, but instead that it's Congress's role that is at issue, and it's that role that led to January 6th, not the vice president. And so I wanted to front load my constitutional analysis, if you will, on both its unconstitutionality and then the specific suggestions for its improvement, and then ending with kind of a back of the hand to the vice president's role, because of your op-ed and Rich's, that there's not any serious question that the vice president has any role at all beyond, in constitutional terms, opening the ballots. According to the 12th Amendment, the vice president doesn't even count them. And of course, as a practical matter, we know that the vice president's never counted them. That ministerial task falls to chosen tellers, selected by both houses of Congress. So now, I'm not going to shy from your critique of my use of the word largely. And as with every other word in that particular op-ed, I angsted over it for a long time, and thought about taking it out in the end, and left it only for this reason. To whatever extent that one thinks that the vice president's only and exclusive role is to count the votes, we know that's not even correct. Opening the ballots, certificates, is that ministerial? Yes. Does the vice president have any other role at all beyond opening the ballots? Yes. I mean, it's more than ceremonial that the vice president presides over the joint session for the counting of the ballots. And I wanted to leave room, some elasticity in that ministerial function. Think of it as a necessary and proper clause adjunct to the ministerial function, so that he can execute his ministerial function through the necessary and proper means, whatever they might be. For instance, Alan, now that just what comes to mind, in receiving the objections from the two houses, that's not counting the ballots, but it is largely a ceremonial role.
And even as you say, I think as you just mentioned or alluded to briefly, the ceremonial role, the majesty of it, the dignity of having the vice president preside is, as one of our audience members just asked a question, the symbolic importance of it is not trivial. The fact that it is the assembled representatives and senators of the United States at this august transfer of power from one president, one administration to another, the fact that the vice president presides is symbolically significant. The dignity of our institutions is crucial to maintaining traditions, which is why the disruption of it with the insurrection was, among other reasons, as significant as it was. This was a hallowed process overseen by a constitutional officer of the vice president.
Alan, hearing you say this, this brings to mind this point. I think over a week ago now, I commented for the Washington Post on Senators Durbin, King, and Klobuchar's discussion draft, as they characterized it. And one of their suggestions is to eliminate the vice president as the presiding officer over the joint session. Now this will be real interesting to all of us here today, and I want you to tell me if I'm wrong on this, but this was my thinking, okay? In the Washington Post, I said that I had constitutional concerns about a couple of things, including that. Now, when I wrote those words, I went back to the 12th Amendment, I apologize if this is just too much of a digression, but I went back to the 12th Amendment to be sure if I could say that without Alan Rawl, calling me up short. And what I saw in the 12th Amendment was not, that the vice president presides over the joint session. And then I realized it's Congress who determines who presides over the joint session. Nonetheless, I left in that criticism to raise a red flag as to the elimination of the vice president from being the presiding officer over the joint session, because if you take him out, it's significant for many of the reasons that you articulated just now.
Yeah, although of course there is an inherent conflict of interest in the, the vice president presiding over a potentially disputed election involving his or her, perhaps even his or her own self, depending on who the candidate is. So
there's that same inherent conflict in whoever you choose, unless, I thought to myself last week, Congress were to make the Chief Justice the presiding officer over the joint session. But for instance, Durbin, King, and Klobuchar's suggestion was first suggestion was that we make the majority leader of the Senate the presiding officer. Well, that can't possibly be right. I mean, there's talk about a conflict of interest. So again, this is in the weeds and minutia, but it will eventually be very important.
Well, you've come to the right group for in the weeds and minutia, so just keep it going.
That's why I was intimidated to come here.
But let me ask you, just a segue from the Chief Justice potentially being the presiding officer. One of your reform suggestions is providing an express role for the judiciary in determining the lawfulness of the ballots and so on. How do you foresee that working out, and does that risk further politicizing the judiciary? Not that the judiciary is going to avoid a role in disputed elections, but rather by incorporating them specifically in a reform effort. Would that be, how would you see it working, and are you concerned about the politicization risk?
Yeah, it's if I see that this introduction of a role for the federal judiciary up to and including the Supreme Court specifically as my only contribution, or certainly my main contribution to the discussion. But I am convinced that this is the answer to all of the various partisan concerns. So, right now, the Democrats are worried sick that Trump and his allies in the states are going to overturn the next election. And the reason that the states are so important is, as this group understands, the Constitution gives the state legislatures plenary authority over the electors in their states. So right now, Trump and his allies are whipping up those states and state legislators to exercise their plenary power under the Constitution over electors to swing the next election toward, as I said in the op-ed, either Trump, if he's the candidate, or his anointed candidate, whoever that might be. On the other hand, the Republicans not that they're so high-minded, they've got their own partisan interests exclusively, but one of their talking points, and some of them will even believe it, is the fact that the Constitution vests the plenary authority in the states. Okay, and Republicans, as I made the point in this op-ed, they profess to believe in limited government, and the very last thing Republicans should want is for Washington to take over the election of the presidency, which really is administered by the states.
Mike, Judge Luttig, I'm going to just pose two last questions to you. This has been fantastic. I think that your response here will have to be our concluding thoughts. We're coming up at the end of the hour, a brilliant hour, and I think I know that, speaking for all the audience, incredibly engaging and illuminating, and really frightening in terms of the implications for our democracy, and I think for those still in the Republican Party, existential threat to the party as you propose. But our fearless leader, George Conway, and one of our other founding members and leader, Stuart Gerson, have raised some questions about the problem being the bad faith actors in the states who would exploit whatever language, whatever reforms, and whatever constitutional amendment, or the 12th Amendment. That really what we're seeing is that for partisan reasons, for cult reasons, for whatever it is, that people in power or an ability to exert power, with the exceptions of people in the last election who stood up to the bad faith actors in the states, and also to the erosion of societal norms, as is posed in the questions by George and Stuart. What can we do to rein in bad faith actors seeking to exploit language for partisan reasons and personal power, and where our customary views of fair play and social responsibility and the integrity of our institutions has been eroded? So you might, I have confidence that you're going to be able to solve the Electoral Count Act. What are you going to do about bad faith of individuals trying to exert power and the erosion of our societal norms and faith in institutions and fair play?
Well, of course, we can never control the bad actors, Alan, but to the extent that we place the disputes that are brought by those bad actors in the federal courts, then we don't compound the bad actors that are acting by adding the Congress and other partisans. And then, as to your earlier question about the Supreme Court, the Supreme Court can take care of itself, and once we give up faith in the Supreme Court to decide questions based on the law and believe that they decide them instead based on partisan politics, then we've got nothing left in this country in any event. But your question raises the cultural problem, and I was just on with a college class, and one of the various students had asked me that question, to which I gave this answer. The cultural problem is we the people. It's us.
It is us.
And the government, it's not the government's job, but more importantly, it's incapable of solving the the social problem. We have to do that ourselves. And we better be fast getting to that, because as we've just discussed, you can set up all the checks and balances you want. But if the people are the bad actors. And if they want to frustrate the system, there's no way to stop them.
Well, Judge Luttig, that was brilliant. And with a brilliant conclusion, truly, that we are the problem and we have to be the solution. So I hope you'll join us again. Thank you for joining us today. Keep writing, keep speaking. And I would suggest you get out there and send this message publicly as widely as you can and you're inclined to do, because it does make a difference. So thanks for being with us, and keep talking to the public as well, in addition to senators on a bipartisan basis and vice presidents and others. Thank you.
Thank you so much, Alan, and all the friends that are on. I just love all of you to death. Take care.
Good day. Very much reciprocated. The feeling is mutual. Thank you. Bye-bye. Thanks all for joining.